Oh, all right, yeah.
Hello and welcome back to the Senate Committee on Government Operations meeting for the final Friday of March 28th, 2005. And our final item to come under consideration is a House bill. And we had this scheduled for, gosh, I think it was Wednesday, and the floor went 3 hours, and we have it scheduled today. And we were a little late getting down, but we're going to take up H1. This is the act related to accepting and referring complaints by the State Ethics Commission. And in deference to the House Judiciary Chair's time, we're going to have Martin Lalonde talk to us first about how this came about. And then we have Pledge Counsel Michael O'Grady. And finally, but not the least of which, we also have Professor at Vermont Law School, Peter Teachout, who's a familiar face around the building. Martin, welcome. I assume you know all of us. So
I do. Thank you.
Let us bring us up to date.
Yeah, thank you for having me, Chair. Martin Lalonde, representative from South Burlington, Chair of the House Judiciary Committee, and more important for this, Chair of the House Ethics Panel. Last summer, became aware in the ethics panel of this issue. Was brought to our attention by the individual staffing it, Michael O'Grady and Betsy Ann Rask also are staffing that for us. So we had kind of missed the fact that the law that was passed had this problematic provision, which impinges on our sole authority under the Constitution to judge the qualifications of legislators. The Senate panel, ethics panel for senators, the House ethics panel for House members. So we saw that, and my intention of what I wanted to see as a result of that is to get rid of that impingement on our authority, and yet continue to get advice and input from the ethics commission.
Sorry, I'm having a hard time. I don't understand how it impinges on it, given that all the complaints can come into the Ethics Commission and then they get sent right away to the House or to the Senate or to the Judiciary or to whoever. I mean, how's that impinging?
Because it has a 60-day period that you have to consult in writing before we make a decision, and having that
because the time frame
is a big part of it. Yes.
Okay,
yeah,
but the way it comes in isn't the problem.
No, in fact, what we want and what the solution is that when the referral comes to us, give us your recommendation then.
Yeah.
So we have the ability to get their expertise at that point, and there's nothing that keeps us from going back and consulting with the commissioner after that. So I'm not sure why, except perhaps I can understand the one area that might be problematic for this is the resources that the commissioner has on having to give us, right, but that's not, we shouldn't be undermining our constitutional authority because there's some resource needs at the ethics commission, in my view, because the way, again, the setup is that we get the advice. It's not binding. It can't be binding on the legislature. It can't be binding on the courts either, because the courts, I hope you'll hear from the courts as well, who have the same issue. We get to essentially judge our own, although we will certainly take input if we believe that that's important for our determination. So that's really the crux of it. I know there's a lot more technical, but I leave that, of course, to legislative council.
Thank you very much.
All right, thank you. Weekend. Yeah, you all have a good weekend as well. I would stay and listen, but I do have another meeting I have to get to. So.
Oh, you're finally off the floor.
Yeah, exactly. Thank you.
See
you. Thank you for joining us.
I like a different role of O'Grady. I think it's a great sort of I don't ever see you in this capacity. I see you water steward, and it's so nice to see you in an
I'm the dirt and the waste guy.
Yeah, you are dirt, but you are dirt and waste.
Right. This is Michael O'Grady, Legislative Council. Let's kind of just step back a little bit and kind of look at why there is a potential likely impingement on the legislature's authority. The Constitution gives you authority as the General Assembly, Senate, and House, respectively, and you have power to judge the election qualifications of your own members. And the courts have said that those are your sole authorities. that no other entity, no other branch can exercise jurisdiction over your discipline and your review of the qualifications of your members. And you have affected that authority through your rulemaking. Generally, your rulemaking authority, procedure, process, but also through your ethics panel, your discrimination panel, etc. And you have your own rules for how the procedure for those panels operate. Now, legislative rulemaking is a core legislative authority. It is granted by the Constitution. It is yours alone to exercise. No one else can exercise legislative rulemaking or set legislative procedure. So 2 core legislative authorities: judging the qualifications of your members, setting your rulemaking and the procedure that you follow underneath your rulemaking. Core legislative functions. No other branch of government should have any input or interference or any activity in those 2 legislative core functions.
Okay.
But you come to the bill that was enacted last year. And it has a provision in it that when the State Ethics Commission receives a complaint, they send it to the respective panel, the Senate panel, the House panel.
Yeah.
And it says that any entity receiving a referred complaint shall consult with the commission regarding the application of the state code of ethics to facts presented in the complaint. And you shall have 60 days to do that consultation in writing. So you've now just established a procedure in statute that involves the State Ethics Commission in your core legislative function of reviewing the qualifications of members, and you have amended your legislative procedure by statute. Those are 2 things that are your core function and should not involve the State Ethics Commission, and you shouldn't be setting your legislative procedure in statute. Generally, when you adopt your rules each year for each biennium, that's what controls your procedure. Statute that might exist, that might theoretically control your procedure, doesn't control from biennium to biennium because your rules supersede statute. And you're not going to find any Vermont case law saying that because the courts, under its doctrine called the political question doctrine, keep themselves out of the procedure and the core legislative functions of the General Assembly. But if you go to a resource like Mason's Manual, it will show, it will tell you that legislative rules have precedence over statute. So that's where you are. And I think the chair of Judiciary, chair of House Ethics, explained well what this amendment would do. It is not removing consultation with the State Ethics Commission. It is asking for their recommendation when the complaint is referred. It is allowing for consultation to continue, but it doesn't affect the procedure that the panels would take in judging the qualifications of its members. And it isn't a mandate for them to seek consultation with the commission in order to go forward with their core legislative function of reviewing the qualifications of its members. It is in the spirit, but it is technically protective of the core legislative powers and authorities.
Do you want to just walk through the bill itself and talk about the changes?
Sure. So you can start on page 1, H1, section 1, line 5, 3 VSA 1223. This is the entire procedure for accepting and referring complaints that the State Commission, Ethics Commission receives. You'll see there's a preliminary review by the executive director to determine all relevant entities that might be involved. Then you'll see on page 1, line 21, that with relation to legislative and judicial branches and attorneys, if the complaint is in regard to the Senate senator, it's directed to the Senate Ethics Panel. If it's regarding a state representative, it's directed to the House Ethics Panel. If it relates to a judge, it goes to the Judicial Conduct Board. If it relates to an attorney employed by the state, the executive director refers the complaint to the Professional Responsibility Board. Sorry. Yep.
We did that.
And then going on page 3, there's a provision about municipal code.
Senator White.
Thank you, Chair Collmore. Council O'Grady, if we dealt with this with the sexual harassment prevention panel, where there doesn't seem to be a place for folks who serve in the building, specifically the lieutenant governor, within this. So I don't see them, although, you know, he's the president of the Senate. Where would the lieutenant governor fall under this? And is there an ethics code that's separate for that group of folks, whether it be
For
the
the
lieutenant
executive
governor?
branch, because he's in the executive branch.
Well, and yes, just you could tell me about state level folks and where they fall.
So this authority is focused on ethics. It's not focused on sexual harassment and prevention of discrimination.
Thank you for that point. Yes. The example I was trying to use is we had this gap identified within the sexual harassment prevention panel work too, because they're not called out. So apologies. Yes.
So for ethics, there are the code of ethics applies to state employees, and the lieutenant governor, I'll have to review, but I'm pretty sure lieutenant governor is listed as being subject to the state code of ethics.
Yeah.
So if you wanted to have a complaint against the lieutenant governor, you would refer that complaint to the state ethics commission. Because the lieutenant governor, even though president of the Senate, is not a legislative employee, is an executive branch employee, he does not fall under the umbrella that discipline that you have as a body underneath the Constitution. So that is why,
Interesting.
when there was a complaint,
Yeah.
sexual harassment, you didn't have jurisdiction from it because your policy applies to senators, employees, and other persons effectively compensated by the legislature.
Okay. Thank you. Interesting.
Okay.
So on page 3, line 5, in that consultation on unethical conduct, if the executive director receives a complaint, goes to the various bodies that I just reviewed, the director shall signify any likely unethical conduct described in the complaint, and then any entity that receives it has to, it says shall consult with the commission, and the commission is an executive branch entity. There's some dispute by the commission that says that they are not an executive branch agency, but literally within their statutory authority, it says they are created within the executive branch.
They like to think of themselves as separate altogether.
They do somehow, they are separate from the executive control by the governor.
Right.
They are within the executive branch as it states in the statute.
So just to follow up on
Yeah.
that, is there any other office like that that is that is managed under the umbrella of the agency of administration, I assume, or executive branch, but that is not doesn't report to the
Probably the closest is the Office of Racial Equity.
well, but they report to the governor. I mean, that's a direct report.
But do they? I thought they had some independence.
Oh,
I think they're appointed by the governor
They are.
as the State Ethics Commission.
as is the ethics commission. Anyway, we'd have to look at both those. Yeah.
So there is that mandate for the judicial board, for professional responsibility for attorneys,
Right.
ethics panels, to consult with an executive branch agency about a core constitutional authority that all of those entities have for the qualifications of their members. And you will see that that is being proposed for change page 3, line 12, for complaints referred under subdivision B4, those are the ones from regarding the legislature or the judiciary or attorney. The executive director shall specify the application of the state code of ethics facts presented in the complaint and include a recommended action. Again, there is that opportunity for the commission to provide input, but it doesn't interfere with the process of the legislature or the judiciary. With all other complaints referred under subsection D, an entity receiving a complaint shall consult with the commission regarding the application of the state code of ethics. The consultation shall be in writing and occur within 60 days. That does not apply to the legislature and the judiciary under the proposed amendment. And that, except for page 4, is the end. Any advice the commission provides during the consultation process shall be confidential and non-binding on the entity. Now, when you enacted the bill last year, you made it effective in September of 2025. So this consultation process hasn't even been implemented.
Yeah.
It's not effective. The effective date on page 4, line 5, section 2 would clearly control. It would say that the effective date of this act shall supersede the provisions in Act number 171 that amended previous A 1223, and that conflict with the language in this act. So this act will control over 171. So again, it is not removing any participation by the commission. The commission still can provide its input, provides its input when they refer the complaint, not after the complaint, doesn't impinge on the legislature's procedural rulemaking authority or authority to judge the qualifications of its members. And I think you have already received a memo from the judiciary that is along the same lines. Let's say the legislature and the judiciary are aligned in the need to make this amendment.
We actually had him scheduled to testify, I think Wednesday, but again, we literally ran out of time. Professional, well, I can't remember the exact one is. There were 3 of them. Terry Corsons was one. And
Merrill Ben.
yes,
And Paula.
yeah. So we'll probably have him come in next week at some point. Okay. Does anyone have a question from Michael O'Grady regarding the language? Senator White?
Thank you, Mr. Chair. This doesn't change in any way the scope of what an ethical violation is. It just changes kind of the process. Is that a fair way to put it? Or does it change the scope?
You know, it's an interesting question because one of the things that the director of the State Ethics Commission has been saying that why consultation is necessary is so that all branches have a uniform application or a uniform understanding of the state code of ethics as it applies to them. There's never going to be a uniform application because the legislature and the judiciary have separate codes of ethics that are their constitutional authority to adopt. The legislature's code of ethics, especially with regard to conflicts of interest, is entirely different from the state code of ethics that the Ethics Commission has adopted or implements under statute. You could never comply with the state code of ethics conflict of interest provisions because you are in here every day. You all pay property tax.
Yeah.
You all drive cars. Some of you are teachers. Some of you are lawyers. Some of you are farmers. If you had to conflict yourself out every time, according to the state code of ethics, conflict of interest, you would never do anything.
Well, we'd never be able to vote. Yeah, I mean, there'd be fewer things to do.
It would take you much longer. There would be, I mean, you had a procedural debate on the floor about waiving a rule today that took like 2 hours. You'd have similar issues.
I don't think the 2 chambers panels are 100% in agreement either.
No, they're not. Your how you operate is different from the House. And that's your prerogative because that's your constitutional authority. You, Senate, can adopt the rules that judge your members.
Yeah.
That's,
Other questions for Attorney O'Grady? Michael, thank you very much. As always, great to see you. Have a good weekend.
Do you want me to stay
You're
or?
welcome to stay, absolutely.
This is the first
Peter, if
time
you want to join us at the table?
This is the first time all week I've seen that time to be able to stay
Yeah.
anywhere.
So, very quickly, we'll introduce ourselves and, hear your testimony.
I'm gonna have to leave at 3 because I gotta get to Putney.
oh,
But
Excuse yourself.
it's Senator Larry Hart, Orange County.
I'm sorry.
Senator Larry Hart from Orange County.
Yes, I know you. Yes, Senator Hart. I thought you had to excuse yourself. Okay. Nice to meet you. Okay.
Allison Clark's in the Windsor County District.
Brian Collmore from the
Yes,
Russell District.
Jillian, committee
Yes,
assistant.
and Senator White from,
Oh, yeah, hello. Nice to meet you. Don't
We
need any-
have the honor of representing Peterson.
okay.
So,
My name is Peter Chicho. I teach law at Vermont Law School, my area of specialty, state and federal constitutional law. I was asked to take a look at a question, and the question was whether exempting the legislative branches was required by the separation of powers clause in the Vermont Constitution. Now, since H1 was initially introduced and passed now by the House, you now have expanded the exemption, as I understand it, to the judicial branch. I may be wrong about that, but that is my understanding. In any event, when I was asked to look at it, I was asked to look at it in the context of whether exemption of the legislative branch is required by the separation of powers clause. Now, my conclusion, contrary to Representative Lund and Legislative Counsel O'Grady, is that if you know what the separation of powers clause in the Vermont Constitution requires and what it does not require, requiring the legislative branches to participate in the consultations contemplated by 1223 does not violate the separation of powers clause. I've heard the arguments. I respect them. I know what underlies them, but I don't think they are sound legally here. And if you could allow me to explain briefly why, I'd be happy to do so.
please do.
Okay,
We're here.
5 simple points. First, to step back from the point that Attorney O'Grady just made. He said, it's impossible for all the different agencies and branches of government to comply with a single uniform code of ethics. I agree with that completely. That is not my understanding of what the underlying endeavor here is. My understanding is the endeavor is to develop and implement a comprehensive, coordinated approach to treatment of ethics violations in government. Now, by that, let's just be clear what that means. It doesn't mean adopting a single uniform code of ethics. It means maybe adopting some minimum standards that are universally shared, but it recognizes that each branch, each body may have its own particular needs and requirements, and therefore tolerates and would tolerate variation. Yeah. And that is sort of built into the system. What it does contemplate, however, is that all of the agencies of government go through the same essential process in reviewing and deciding ethics complaints. And I think it also contemplates that there'll be a certain, maybe a high degree of coordination in the development of this comprehensive coordinate. That's my idea of what the underlying vision is. Point number one. Point number two. I think the problem that I have with what I've heard about the consultation agreement is that it is seen as kind of a technical requirement that's going to interfere with the ability of the legislative branches to make responsible decisions about how alleged ethics violations should be reviewed and how they should be decided. If I could just spend 1 minute now to say that's not the role that consultation is supposed to play in this process. I have prepared a memo and all of this is spelled out, but if you turn to, I think it's page 3 of the memo, I just step back and I said, oh, you know, what purpose does the consultation requirement serve and why is that important? Well, as Attorney O'Grady has said, you know, it comes after the director has referred a complaint to the legislative branches in this case, and doesn't even refer the complaint unless the director's made a preliminary assessment of whether the complaint has merit. But anyway, it's sent over, and then the body, the legislative branch, is perfectly free to investigate that complaint. Is it based on the evidence? Is it supported by the evidence? To determine how serious it is, whether they want to act on it or not. The commission in this case, it's important to know, does have investigative and hearing powers. Not the Rules Committee may not, it doesn't matter. But anyway, the commission could serve the Rules Committee by conducting an investigation and determining, in fact, if the evidence bore out the complaint. It's quite possible that a person alleged to have committed an ethical violation would say, I never did it. So now let's just imagine that consultation process and how it works. The interesting thing, you read the law, is really bare bones. There's no definition in the law itself about what the consultations need to require, about the participation in them is going to require. The only requirement is that at least it be in writing, but that doesn't preclude, of course, the commission meeting with some representative of one of the rules panels and saying, you know, what do you think about this? But anyway, that's the only requirement. It's got consultation, got to be in writing. Okay. But I think if you step back from that, you think, well, how could this process actually help the bodies involved, the bodies charged with making final decisions, make more responsible, more thoughtful, more fully informed decisions? Here is what I'm going to say. I list this on page 3. I'm sure there are many other examples. For one thing, consultations provide a check against hasty decisions. 2, they provide an opportunity to share information. For example, if the commission has investigated and determined, hey, this complaint isn't supported by the evidence, or it is supported by, this provides an opportunity to share that information. They provide the government body responsible for making decisions with an opportunity to learn from the commission's experience, and over time it's going to develop experience in dealing with similar kinds of problems in other contexts. It provides an opportunity to discuss alternative ways to approach an ethics. People think, hey, the answer is right up there on the shelf. That is not the way ethics decisions are made. About alternative ways to approach the ethics violation and alternative ways to dispose of it, right? To decide it. I think that benefits go actually both ways, because it provides the commission with an opportunity to learn from and appreciate the special kinds of considerations that a particular legislative branch may have or another body of government may have that might shape the way an ethics violation ought to be decided. Simple point, I just think the consultation play an absolutely crucial role if what you want to have in the end are decisions that are responsible, thoughtful, and fully informed. Now, all of that has nothing to do with my area of expertise. I'm just telling you that. Think carefully about that before you just say, hey, no problem, we can just dispose of that. Okay, now let's go to what I do know about. What I do know about is what separation of powers doctrine requires under Vermont law, and I know what it doesn't require. You heard Representative, I'm sorry to have elevated it.
That's a
Representative Lalonde say, hey, it might require devotion of some of the resources of the legislative branch or the Rules Committee. Hey, look, every law every law requires that somebody, some body of government, some branch of government devote some resources to it. That's not a separation of powers test. And I'm going to come back to that. What about laws, and for just a moment, what about laws that require a certain element of inter-branch cooperation or collaboration in the implementation of important state law? Does that violate the separation of powers? And the answer is clearly no. What does the separation of powers do? What's the test? Okay. You want to read the separation? I know we shouldn't do that. You want to read the separation of powers clause? I have it set forth on page 5.
Or ethics commissioner, or you're on the ethics panel, right?
I am on the ethics committee.
Oh, I wish
have
you were
all
able
this
to
stuff
say.
already.
Okay.
Yeah, I'm on the ethics panel for
Look
the
forward to
Senate.
having you then see it.
Yeah,
Watch it on YouTube.
I just gotta get to Thetford before 4 o'clock.
Putney, I thought you were going to Putney.
I'm
Oh,
gonna pick my wife up in Thetford and then we're headed to Putney.
I see I've only got 3 members of the committee. That means only 3 bails A. So let me give you all 3. Number 1 bail. Okay. Read the separation of powers clause. It says legislative, executive, and judicial department, this is page 5, shall be separate and distinct so that neither exercise the powers belonging to the other. It doesn't say so that no branch of government is somehow required to collaborate with it. It says so that no branch of government exercise. And you say, where does that come from? I will tell you that's the core test the courts have applied, sometimes with slight variation. Sometimes they say if one body exercises powers that effectively usurp the powers that another body should perform, that's basically the same thing. Or so interferes with a body's ability to perform its assigned constitutional functions as to prevent the performance. That constitutes. But the test, really the core test, is exercise. Where does that come from? I will tell you where it comes from. It wasn't in the Constitution in the first instance. There was no separation of powers clause in the first Constitution. It got added in, this is instructive, in 1785, 1786, 1786, because in that period, from the founding of the state up until the end of the first September, however you put it, the first 7 years, the legislature in the state was unashamedly grabbing and exercising judicial power. I explain that. I give you the history on the bottom of 5 and the top of page 6. How did they do that? They took whole bodies of decision that used to be allocated to the judiciary and said, judiciary can no longer make decisions in those areas. They considered and entertained individual bills in which the legislature basically overturned final judicial judgments by saying, we now decide that X who lost in the courts should not be required to pay Y as the court report. This is the legislature was, no, but hey, look, this is early days. No, I didn't know
We're new
exactly.
to it.
But anyway, the Council of Censors, which was the body charged with reviewing acts of legislature to determine if they're consistent with the law, said that is a violation of whatever possibly could be understood as proper separation of powers of government. So that's how it comes to be. But notice that was an instance in which the legislature was actually exercising judicial powers. Now, Attorney O'Grady, who I know and like, know a little bit and like and respect, said that there's a case out there called Grady versus Dean, in which the court declined to exercise jurisdiction, right? That's a classic instance of separation of powers difference. Why? In that case, what happened? A group of legislators got together and they joined a pool betting whether a certain piece of legislation would pass. And then Number of them voted on the legislation.
Oh, of course, they influence it.
Ensuring the result.
Exactly.
And of course, Louisiana said, hey, wait a minute, that's a conflict of interest violation if I ever saw. So they go to court and they say to the court, step in here. Court declined. Why? Because the court said, under our Constitution, the legislative branch has sole prerogative to judge the qualifications and elections of its members. It says the legislative branch are solely and exclusively responsible for making decisions about whether votes should be disqualified or not disqualified. This is separation of power. They said we can't do it because if we did that, it would be the judiciary exercising a power that has been granted exclusively. Yeah. So those are two examples of what is meant by separation of powers. I will just say, hey, the test is exercised, but there's a little penumbra of slightly varied expressions of that test that you find out there. Now, if you look at the whole spectrum of types of legislation, you will see there's a little cluster up here where the court has said separation of powers violation, and they all involve usurpation of a power or exercise of a power or legislation that so impairs the ability of a body to perform its assigned legislative functions that it prevents them from doing so. The whole rest of the spectrum, I will tell you, involves all those other cases where legislation calls for some form of inter-branch collaboration, which means, of course, a certain devotion of resource, inter-branch collaboration in the implementation of state policy.
Senator Wade has a question for you.
Thank you, Mr. Chair. I am totally not following any of this, just to be completely transparent with you. I don't understand how this is relevant to what we're talking about. Okay, can I just, I'm not a lawyer. You're all,
Hey,
you have more.
that's
So
perfectly fair.
can I
I'm
ask
glad
a
you
question?
interrupted. Okay.
Yeah.
So why relevant?
Yeah, so can I just ask a couple questions to give an example so that I can understand?
Yeah.
So you're saying that the Ethics Commission, because it is a separate branch of government, we as a legislator shouldn't be beholden to them because we have a separation of powers?
No.
Okay, can you just say it in like
No, that's-
really,
no,
because I'm not a lawyer.
No, that's
I'm not following it all.
That's
I'm so
extremely
sorry.
helpful, and I feel terribly that you haven't been following, but this you
I'm listening. I'm really trying to get it.
No, but that's really a nice question. So my question is whether requiring the legislative branches to participate in these consultations violates the separation of powers doctrine.
Because it's all about the consultation, whether the.
Yeah, the
ethics-
consultation is us just saying, hey, is this an ethics violation to the state ethics board? And you're saying if it's in writing, it's a violation of the statute of powers?
No, that's what
That's what Mike is
So-
intending.
That's
so
what you're saying.
And Peter's
he's
saying the
saying
opposite.
that the courts allow for some overlap of authority.
Right.
And that there's only a separation of power when there's a total usurpation, when they totally take the
Take
power
away.
from the other branch and exercise that power.
And
And he's saying that what the consultation in the current law, which you passed last year, is not a violation. And I am saying it is, so is Representative Lalone. And I can give examples of why
Yeah,
it
what's an
is.
example?
It is a separation of powers issue. And I don't want to interject any further.
No, that's helpful.
So an example, so the reason it is a use potential, so you're debating whether or not it's a usurpation of our authority. And you're saying it isn't, and you're saying it is. And you're saying it isn't because historically we have had the ability to do this?
I'm saying it isn't because the separation of powers clause itself establishes the standard to be applied. It doesn't apply to all those situations where there might be an element of interbranch collaboration involved in the implementation of state law. It only applies when what's involved is one branch ends up exercising powers that under our constitution are assigned to another branch.
Belong to another branch.
Or restricts the powers.
Or so restricts it that the branch
Cannot
assigned with
exercise
these
its authority.
can't perform those responsibilities. And my difference with Attorney Grady is the consultation requirement not only don't interfere with the ability of each branch of legislature, including the Rules Committee, to deal with these problems however they want. All it does is say, before you make a final decision, let's talk.
But what if a consultation, what if they said, we think you're wrong in their consultation? Wouldn't that kind of be?
No, perfectly good question.
I'm really proud.
No, that's.
You're asking.
So no, but that is a core question. What if the Ethics Commission says, you know what, we recommend, boy, this is terrible. We recommend that senator either.
We resign.
Take a case where a senator might have a farm and he rents out housing to tenants and we find out that the tenants are allowed not to pay rent if they perform certain sexual favors.
Never happened in ours.
Never happened. Okay. I'm just saying, okay, but your question is this. Suppose the Ethics Commission says real violation of ethics standards by any measure. And the Rules Committee comes back, they might say, well, we think it's a violation or we don't agree with you. But in any case, we need that guy's vote. And so we're not gonna sanction the individual. We're not gonna find a violation. We're not gonna sanction it. Now, does the Ethics Commission have any power to force the Rules Committee to adopt its view of whether there is a violation or what sanction, if any, is appropriate? The answer is absolutely none. The Rules Committee is absolutely free to make whatever final decisions it decides on the basis of its own proceedings is appropriate in a particular. That's the way it works. Do you understand that?
I understand that, but
Okay,
so
now-
why, but to that point, if there was a difference of opinion.
Yeah.
And the opinion that the Ethics Commission had was that they were in violation of an ethical standard
Yeah.
and there's no recourse. But I don't understand how that's possible. Like that makes it makes it illogical that we
Okay.
even are consulting. them.
Okay, now I'm gonna give you the answer to that. I know. Okay, hey, look. The commission under Vermont law, it's not true with ethics commissions, has absolutely no enforcement powers. It can investigate, it can recommend, but its recommendations are not binding,
Mhm.
and there is no requirement that the government body involved, in fact, accept or implement those recommendations if they want to go their own way. The law says Ethics Commission has absolutely no right to determine what the final decision is.
They can't determine it, but they can consult.
And that's a matter of law because the commission has no enforcement power.
Right.
It can
They
recommend-
eventually could get enforcement
Well-
power. I mean, we
Well,
separately could, so that your position would change if they did have enforcement.
That is, I think it might have,
I think-
but in this case, in the state of Vermont, the Ethics Commission doesn't have enforcement, unlike in New York, for example.
Yeah.
Yeah, okay, so that's really important, because what it means is that the legislative branch is perfectly free to conduct its own investigation, make its own determination. It can consult with the commission, but whatever the commission recommends is not binding. I've suggested earlier that I think that consultation would be beneficial.
Yes.
Everybody would benefit from it, but will not lead to a binding. So I'm just giving you the separation of powers judgment. That wouldn't be a violation of it because the legislative branch is free in the end to make its own determination. Okay.
I think I understand. the
Okay,
side.
now-
So
now-
Professor Teachout, I think Michael wanted to make.
Yeah, go ahead.
You're correct that they're free to make their own determination, but they're not free in their process. The panel's authority only extends during the duration of the biennium.
Okay, only,
Extends during the duration of the biennium. It's only for a 2-year period.
Yeah.
So a complaint comes in at the end of the year, which they do, because I have staff ethics issues for over 10 years, longer than the State Ethics Commission has been in existence. And when they come in, the panel has to act quickly in order to assert its jurisdiction over that representative or senator. And if they have to now, in writing, consult with the State Ethics Commission and wait for the State Ethics Commission to respond, you've impaired their process. And you might even have robbed them of jurisdiction over the member in that situation.
Oh, because they could be unelected or not at the end of their term.
In addition to the example, the example you gave, which I was involved in, the panel moved quickly as a body to address the issue and to determine what the action was going to be. The panel didn't need to consult with anyone else. It shouldn't have consulted with anyone else because it was purely within the core legislative authority. They did consult with law enforcement, which was probably the appropriate consultation. And they took the action that they thought was necessary at that time in order to both provide discipline and to recognize the due process of the member in that issue.
I remember, okay. So let me say, Michael, I agree with you completely. I agree with you completely. And I have given it some thought. If you turn to page 10 of my memo, you don't have to, section 4, I said to myself, look, is there any situation in which it could be fairly argued that consulting with the Ethics Commission might interfere with the ability of the rules panel to make a final decision? That's what you've raised, right? And I agree that that's true. It might operate at the other end as well, but at least, and so I said, well, I can think of a situation. There might be a situation where the rules panel has to act right away because of exigencies, and there's not time to arrange for a consultation. Now, I think that is a situation, in fact, in which there might be a separation of powers problem.
Oh.
But I don't think you need to grant the legislative branches blanket exception
Carte blanche.
from complying with the consultation agreement because it can be solved by a very simple amendment. And I have in fact given you the language of the amendment in my memo on page 10. I said, what about something along these lines? If the rules panel of the legislative body charged with responsibility for making ethics decisions determines that a final decision must be made before consultations can be arranged with the Ethics Commission, it shall so notify the Commission, and in that event, post-decision consultations may serve as a substitute.
Well, wait, can we just consult with them now?
Well,
Like if we wanted to consult with them now, we could just do it. Right? Like if let's say there was a situation, there was an ethics complaint, the Senate ethics panel could say, you know what, actually, we do want to bring in the ethics folks. We could just do that.
yeah.
Okay, so I guess no? Oh,
The Ethics Commission does not have authority over the qualifications and discipline of legislators and for the core legislative function.
but if we wanted to, we could talk to them.
Which we,
The Ethics Commission of the
You
Senate.
can talk to them,
Absolutely.
sure, you
Yeah,
can
bring them in.
consult with them, but they're not
Yeah.
the ones that are gonna be
They're not
Maybe
determined.
reviewing and
Yeah.
determining.
So if,
So
so
we're
isn't
clear on that, but I think what Becca's saying is we could bring in the Ethics Commission at any point during the course of our proceedings and discuss with them the merits of the case.
Including when they send when they refer the complaint. I don't really see the difference between from when they refer the complaint and what's just proposed.
let me tell you the difference, because when the ethics complaint is received by the director of the Ethics Commission, it's just a complaint.
Right.
the director makes a preliminary, it's called preliminary review. Does this complaint have merit or not? Does it actually allege an ethics violation? At that point, the Ethics Commission refers the complaint. But between there and a final decision, there might be a need to find out if that complaint, in fact, is borne out by the evidence.
There's no timing requirement on when the referral, there's no timing requirement on when the referral is made. So if the commission gets the complaint, wants to investigate before they refer,
It
in order
could.
to determine their recommendation, they can do that.
So I don't know what the word preliminary means, then if it doesn't mean preliminary. Preliminary means preliminary, okay? So it doesn't say shall conduct a complete investigation, a preliminary review. So I don't think we disagree, Michael, that it's quite possible that the commission could refer a complaint. And then there and between the time a decision has to be made, there could be quite a bit of investigation by the commission and by the rules panel if it wants to conduct it. So in any event, and my basic point here is you don't need to grant the legislative branches a blanket exemption from compliance with a consultation requirement. If you can deal with that by a very simple amendment saying in that event, hey, just let the Ethics Commission know. And we can't wait and go ahead and make the decision. In that case, you'd have to settle for a post decision. And that would serve some purpose, not the same purpose, but at least would allow for this kind of coordinated approach that otherwise would never happen.
Can I just sort of sum up what I think I understand in all this? Is that it's as long as the consultation with the Ethics Commission does not impinge on the ability of the legislature to exercise its core responsibilities, we're fine.
We're fine. No,
I don't see this. I feel like this is a mountain being nailed out of a molehill.
or a constitutional tempest.
A constitutional tempest in a very,
What is that?
In an ethics,
What's the constitutional tempest?
in a
A
teapot.
storm.
Oh, a constitutional storm.
yeah. So look, there.
So, Peter, can I just-
but you find in the case all the time, you have these cases where some form of inter-branch collaboration, and the court clearly says, I'm just so you understand what the court says. This is from the quote on page 8. There are many powers and functions. The focus of a separation of powers inquiry is not whether one branch of government is exercising certain powers that may in some way pertain to another branch's, but whether the power exercised so encroaches upon
Right.
another branch's power as to usurp from that branch its constitution. That's the test that the court applied. And you don't have the problem of usurpation or exercise. So but you could, if you feel like it, you could say, we don't care about the separation of powers argument. We just don't want to participate in consultation. I don't think it's wise, but you could do that. My only question is, does it violate the separation of powers? The consultation agreement, separation of powers clause in the Vermont State Constitution, and the jurisprudence is crystal clear. It does not.
Did you testify before the House?
No,
So that is what was my next question, because it's clear you didn't.
no, I didn't. No,
Because otherwise we wouldn't have this bill, quite honestly, I don't think.
I'm taking it that wasn't by your choice.
I don't think did they just fail to ask you?
I don't mean to
no,
put
no,
you
no,
on
no.
the
It
spot.
wasn't by my choice. It was just that I didn't even know
Okay.
the House was going to be considering it and deciding it. I think it was on a Friday until I was told after the fact, whoops, they've already decided.
Okay.
Oops.
So I think it's too bad because I think at least as long as these issues are taken seriously, as long as you understand what separation of powers doctrine requires and doesn't require, then I think I have done my job.
Well, we appreciate that, because we always this is our piece of continuing education. Thank you.
Well, thank you. If there's any other, thank you, Senator White, for harassing me. I went on and talked for a half an hour.
No.
You didn't
No,
understand
no,
a
it was-
single word.
I was like listening and trying to follow.
were trying,
You're a
yeah.
law professor. She's married to a law professor. She has a child who's gone through law school. She understands the lingo you're using. The lingo you use
Yep.
is foreign to me, but I think I understand your point and I take it very seriously.
And
So
it's,
thank you.
and it's really helpful to
Yeah.
me to have you say, wait just a minute, I don't understand the thing you said.
No, I thought it was.
Think of me as a
actually
one L. Is that what y'all?
So let me just say, this is like, for me, a three-course meal to digest.
Well, I think for backup, I mean, I think that's. what-
And we're gonna take this up again next week.
And we'll have our
We're certainly not gonna
judiciary.
vote it out today with only four of them, well, now three of the members here. I appreciate a lot of what you said. I'm just a disc jockey, but I kind of got what you were saying. And I appreciate that. But we also, I think, want to talk with our legislative council again to see whether we can, again, find a sweet spot here. Apparently the House didn't do that, and that's fine. Representative Lalonde made a decision with his judiciary committee, and you know, I think we need to probably take some more testimony before we do anything else.
I really appreciate that,
All right.
Chair.
It's always good to see you, Peter. Always good.
Well, and
Good way to
I,
end the week.
Yeah.
I would love to have you go back and actually, I'd love to have Martin give you some time so that you could present what you just presented to us to the House.
I think you may not want to hear a discussion or debate, but I think it would be constructive to
Yeah.
have
So we
Representative
need to be on the
Lalonde,
same page.
for whom I have the highest respect, sitting in the same room. And at least then, as we've done with Attorney O'Grady, at least see what are the points of agreement, what are the points of.
Right.
So,
Thank you.
Thank you. Have a
Thank
great
you. This
weekend.
was,
Um,
this was great.
does anyone else have anything? I do want to go over the agenda for next week, but I will do that with Jillian, with all due respect. And, so unless you want to stay, that's fine.
We trust you.
Well, I appreciate that. So with that in mind,
Yeah.
yes, Senator Clarkson.
I just want to say, it's great to have Pat here because. Pat
Yes,
has
I didn't
been-
recognize you, Pat. I'm sorry.
No,
Pat McDonald's here as well.
Pat McDonald's here, and it's very helpful because Pat McDonald has been here with us from the beginning of even the proposal.
I was here.
Of Pat, which Brian and I are really appreciating your presence because Pat helped bring this to the fore and helped bring Vermont into the 21st century on even having an ethics commission. So thank you, Pat.
Thank you.
Just want to say.
Thank you.
We'll see all of you on YouTube next